So now we're joined by Matt Kennard, Declassified's Chief Investigative Reporter. Matt, can you tell us about what it was like in the court today? We know there were audio issues. How did it go?
Yeah, I mean, it continues a theme with this case, which is it's impossible to get access to the case. You've had NGOs and journalists trying to get access to Julian in Belmarsh and finding it next to impossible. I've been to other hearings and they make it as difficult as possible. Today, people were laughing because half the time we couldn't hear what the audio was. Then they would cut out. The technology looked like it was from like 30 years ago. We were looking at a grainy picture across a courtroom with bad sound. So, first of all, this is an open justice, and it should be, because this is the most important press freedom case in recent history. There's people can speculate about reasons that we're not getting that, but actually, what happened inside, I thought was quite promising. There were two lawyers arguing for Assange, and they went over the basic tenets of the case, which is that this is a political prosecution, which is outlawed by the US-UK extradition treaty of 2003. You can't extradite people for political offences, and he's charged mostly under the Espionage Act of 1917, and espionage itself, case law has shown, is a political offence. So at heart, it should be struck out. They also went through the arguments about how it contributes to the European Convention on Human Rights. One of them, Article 7, is about foreseeability, which is that no publisher has ever been prosecuted by the United States for publishing state secrets. That's never happened. This would be the first prosecution under that. So in 2010, when Assange started publishing the cables, there was no way he could have known he could have been prosecuted for it because there was no precedent for it. So again, another reason it should be struck out and the extradition should be stopped. Article 10 of the European Convention on Human Rights is about freedom of speech and about freedom of the press. And again, this violates fundamental tenets of freedom of the press, freedom of speech. So again, another reason to outlaw it. It was extremely convincing to an independent, neutral observer. The problem we have is that the British judiciary has shown itself from the start to not be independent or neutral. The original Barreza ruling in late 2021 basically agreed with every dot and comma of the US indictment, apart from the fact that it would be too much of a risk to his mental health and he was a risk of suicide, and that was what it was blocked on. But everything else she agreed with. So what we need now is an appeal where all the substantive issues, which they discussed today but not at length, substantive issues are discussed because the stakes are extremely high. As we heard today in the courtroom, this goes to the fundamentals of freedom of speech, free press and freedom itself, because if you violate the principles that they're violating with this case, then it opens up a whole panoply of different options for anyone who comes after Assange to get taken out. I'll finish with this. The scariest part of this, and this was touched on as well in the hearing today, is that Julian Assange did not commit any of the conduct or any of the so-called crimes that the US is charging him with in the United States. This happened outside of the United States. So what this case does is it gives the United States extraterritorial reach to go anywhere in the world, to take any journalist or publisher who's publishing information they don't like and put them in Supermax prison for the rest of their life. And that is, there's barely been a threat of that size to our freedoms ever. So we need to stop this case. What needs to happen and what has to happen and what should happen is that there is an appeal on those substantive issues and he wins. But we'll see what happens.
Fantastic. Thank you, Matt.